Good evening and welcome, everyone. My name is Victoria Fisher, and I'm the Program Assistant here at the Institute for Intellectual Property and Social Justice. Thank you all for joining us today for tonight's session of the Intellectual Property for the People webinar series. This series is a free webinar series designed for and marketed to creators, inventors, and entrepreneurs from communities of color who have historically and continually been locked out of receiving key knowledge and resources related to protecting and profiting from their ideas. In this series, we offer easy to digest and engaging talks on IP rights and navigating the IP system, highlighting tips and resources via live webinars, which are saved as an on-demand video series on our YouTube page. Tonight's webinar is directed to copyright and will discuss basics about the Copyright Claims Board, the types of claims the Copyright Claims Board can hear, and legal resources to be aware of. We're glad you're here for tonight's session and hope that you'll join us for future sessions. Please sign up for our newsletter to ensure that you're notified of future events. And now I'll turn the program over to our session moderator, Jordan Dawson.
Jordan Dawson. I'm a 2L at Howard University School of Law, and I'm just going to introduce Maya Burchett. She's an attorney advisor at the U.S. Copyright Office. She attended Howard University for undergrad. She was a Clio Summer Fellow before she attended Tulane Law School.
Right. Thanks, Jordan. Thanks, Victoria. It's great to be here with everybody. As they've mentioned, I'm going to talk to you a little bit about the Copyright Claims Board. So in context of what Victoria mentioned, what we're going to talk about today is how you navigate through a copyright system once you have a dispute. So again, we're going to cover a few copyright basics, and an introduction to the Copyright Claims Board, the creation of the CCB, the types of claims you can file with us, where to file, the proceeding structure and phases, and where you can find additional resources. And we'll stop and pause at certain points to answer your questions. Okay, so briefly, I want to talk about the types of intellectual property. So IIPSJ has a ton of resources on their YouTube page about the different types of intellectual property and resources. Today, we're going to be focusing on copyright. So copyright protects creative expression fixed in a tangible form, meaning that it protects original works of authorship. So let's talk about first what is a work of authorship. So a work of authorship is a creative work like a novel or a song, a play, a dance routine, visual works of art like paintings, photographs, sculptures, motion pictures, and other audiovisual works, including video games, sound recordings, and architectural works. So what you're really talking about is creative works and creative space, and the products of those creative works. So why did Congress create the CCB? So before the Copyright Claims Board was introduced, federal court was the only avenue to get resolution for your copyright disputes. And this was true no matter the size of your dispute, no matter how many parties there were, no matter if you were a plaintiff or a defendant. If you had a copyright dispute, you had to go to federal court to get it litigated. But federal court litigation can be procedurally complicated, lengthy, and time-consuming and expensive. You have generally people needed attorneys to access federal court and litigate their dispute there. And so why does that matter? Well, people with disputes that don't have high monetary value might not have the resources to pursue federal court. Few attorneys are willing to handle small cases, and creators with high volume, low yield works like photographs, or users accused of infringement who believe their use was fair were kind of shut out of the system. So for example, if you were a photographer who licenses your work for $2,000, it's so much more expensive to go to federal court to litigate a dispute over $2,000. A recent economic survey found that the median cost of litigating a copyright infringement lawsuit, that was less than $1 million in damages, was $350,000 to litigate that type of dispute. So you can see how people were previously shut out of the system, even if they had a case. So what happened? So Congress enacted the CASE Act, which stands for the Copyright Alternative Small Claims and Enforcement Act. It created a 3-member a 3-member board in the Copyright Office. We can hear specific types of copyright claims, including claims of copyright infringement, declarations of non-infringement, 512 misrepresentation claims. I'm going to talk about what these 3 are as we keep going through our presentation. The Copyright Claims Board has a voluntary opt-out system. And all of our proceedings are virtual. We are dealing with cases that have less than a $30,000 damages. It have less than $30,000 in damages. And our cases are accessible to anybody with or without an attorney. So if you wanted to bring a Copyright Claims Board case, you don't necessarily need an attorney. You could advocate for yourself. So you have a copyright dispute. Before filing your claim with the CCB, there are several things to consider, including the type of claim you want to bring, the type of proceeding you want to engage in, and how much you're going to ask for in damages. I'm going to be using a couple of specialized vocabulary words. In a CCB claim, you're a claimant if you are essentially the plaintiff or the person bringing the claim. And if you're defending a claim, you're a respondent. So the first and most common type of case we hear is a case of copyright infringement. So let's talk about what copyright infringement is. So when a copyrighted work, again, that's one of our original works of authorship, a novel, a photograph, a video, a song, is reproduced, distributed, publicly performed, publicly displayed, or made into a derivative work without permission from the copyright owner. Unless your use qualifies for an exception such as fair use. So essentially, someone is using your creative work without your permission. They would be engaging in copyright infringement. So let's take a look at an example. I'm going to use Jordan is going to help me out with the examples. So Jordan is an author who wrote a novel about her adventure selling vintage records entitled My Life in Vinyl. Jordan is on a music novel forum when she discovers that MB Publishing, a company she's never heard of, is marketing and selling her book online without her permission. Jordan can file a copyright infringement claim with the CCB. So who can bring a copyright infringement claim? So in order to bring a claim before the board, you need to be the legal or beneficial owner. So a legal owner is an author of a work who owns the exclusive rights. So those are those rights we just talked about: the right to distribute, the right to perform, the right to display, and has received a transfer of those rights. So if you got those rights through a contract, you can bring the claim. A beneficial owner is an owner who has transferred some of the rights but retains the advantage of ownership. So if you created a song but you sold the rights to a music company but you still retain the right to get royalties, you could be a beneficial owner. Who can you bring a claim against? So this is very important. The Copyright Claims Board only deals with respondents, that's defendants who are inside the United States. So if your defendant is in Brazil, is in Europe, is in Asia, the Copyright Claims Board wouldn't be able to hear that case. We can only hear cases brought against someone who resides, a person or entity inside the United States. Okay. Okay, so what do you need to have before filing your copyright infringement claim? You need to have your registration information, so that you need a copyright registration or a pending application for copyright registration from the office. Any additional information about how you own the work. You need your contact information for the respondent, so that's a valid US address, and you need details about your dispute. So as I mentioned before, the Copyright Claims Board is run by 3 officers who have decades of experience in copyright law. So you don't necessarily need to have legal arguments or present legal briefs when you're filing a case, but you do need to tell us about your dispute. We're going to check in here. Jordan, do we have any questions in the chat?
There's no questions in the chat yet, but I guess another question would be, what kind of discovery is allowed in the CCB proceedings?
So we're going to talk about that. We're going to get there when we talk about the proceedings. Let's finish talking about the types of cases that the CCB can hear. So another type of case that the CCB can hear is a declaration of non-infringement. So it's kind of the flip side of infringement. The CCB the CCB can hear a case for a party that was accused excuse me, let me start again. A party who is accused of infringement can file a claim seeking a ruling from the CCB that their actions do not engage in copyright, that do not infringe a copyright. So the respondent, the person or the business, is someone who has accused you of infringement. If the respondent proves the elements of the infringement claim, you can seek to show that your use was allowed. So let's look at this in practice. This is better. This is a claim that's better shown with an example. So Jordan's back, and Jordan has decided to start a vlog about photographs used in album covers called Jordan's Album Pics. A month ago, Jordan received a cease and desist letter from Maya, a photographer, who says that she's the author of these photographs included in Jordan's vlog, and Jordan didn't have permission to use them. Jordan believes that her use of the photographs, where she's discussing them and their use in album covers, is a fair use. Jordan can file a non-infringement claim with the board. So if Jordan were to win, what she would win is a signed declaration from the board saying Jordan's use does not engage in copyright infringement. So who can bring a declaration of non-infringement? So it's a party with a genuine copyright dispute. So you need to show that there's a genuine dispute at hand. So if you've received something like a cease and desist letter, or if you've received accusations that you are engaging in copyright infringement, you'll need to prove that there is a dispute between you and the respondent about if your use is infringing. Who can you bring a claim against? Again, it's going to be a person or entity that's inside the United States. And what do you need to have before filing? So again, you got to have information that shows that you have a genuine dispute. You can attach documents or other evidence to your CCB case. And it would help to have the copyrighted work, or what they said the copyrighted work was, your work, and how you're using it. Any cease and desist letter that you may get would be helpful to attach. And you're going to need the contact information for the person or entity you're filing the claim against. Okay, and the last type of claim that the CCB can hear is a misrepresentation claim. So misrepresentation claims can be a little tricky, but they're dealing with the Digital Millennium Copyright Act, which established a notice and takedown system for removing content from the internet. Anytime you're perusing or scrolling and you run into something that says content not available, it's likely because someone engaged in the notice and takedown system and had content removed. A copyright owner can send a takedown notice to an online service provider, such as a content sharing website, so all of your social media sites, describing material that someone has posted through the online service without the copyright owner's permission. To avoid liability, online service providers follow specified procedures when they receive these notices, as well as when they receive counter notices, seeking reposting of the allegedly infringing material. And we're going to talk about this a little bit further. The DMCA provides that senders of either a notice or a counter notice may be liable for damages if they make a knowing misrepresentation. So what does that look like in practice? So let's say that Jordan has an Instagram post and it's a photograph, and I see it and I say, hey, that looks like my photograph. I can send Instagram what's called a takedown notice. Instagram can remove access to the material. They'll notify Jordan. She can say, hey, I'm going to dispute this. This is actually my photograph. And then I have the option to initiate a CCB action. It also works if there was a misrepresentation in the counter notice. So I see my work online and I send a takedown notice. The OSP removes access to the material. The online service provider notifies the person that I think is infringing my work. They send a counter notice saying, hey, no, this is mine. And I say, no, it's not. You're engaging in copyright infringement. I have the option to initiate a CCB action at that point. So I have another example here. Jordan sees a chapter from her ebook, My Life in Vinyl, up on a social media website and submits a takedown notice. The website removes the chapter and notifies the poster, MB Vinyl Lover 15, that the content was removed. Maya sends the website a counter notice saying that she owns the content. Jordan can file a misrepresentation claim alleging that my ownership statement was a knowing misrepresentation. So that essentially that I knew that it wasn't my work when I filed that notice. Who can bring a misrepresentation claim? You can bring a misrepresentation claim before the board if you believe the respondent said something false to an online service provider in a takedown or counter notice, that the respondent knew it was false, the online service provider took the content offline or put it online as a result, and you were harmed. You can bring a claim against any person or entity residing in the United States. So, Jordan, let's take a minute to see if we have any questions about the types of claims that the CCB can hear.
Yeah, I don't see any questions in the chat, but are there any claims that you keep seeing that are like really popular coming through?
Yeah, so the CCB hears a majority of copyright infringement claims, and we have seen an uptick in copyright infringement claims dealing with video content. So we get a lot of claims from YouTubers or TikTokers or people who are vlogging their daily lives. We see a lot of content from those. We also see a lot of claims about photographs from photographers. And we do see some claims from songwriters and musicians as well. Any other questions?
Are there any like elements of misrepresentation that are kind of hard to prove?
Yeah, definitely. So we have the elements of misrepresentation up on the screen. And so it can be hard to show that that the person that sent the takedown notice engaged in a knowing misrepresentation. So a knowing misrepresentation means that you know what you're saying is false when you're sending this takedown notice. And it can kind of turn sometimes into a he said, she said about whether or not the respondent, your defendant actually knew that something was false when they sent that notice. That can be a hard element to prove. Okay. These are good questions. Let's talk about the next step. So you have a copyright dispute. We're going to talk about the types of proceedings that you can, the two types of proceedings available at the CCB. Okay, so there are two tracks of claims. The standard track is for claims that are pursuing damages up to the full CCB limit of $30,000. The smaller claims track can be used for claims up to $5,000. The smaller claims track has a few key differences than the standard track. It's more streamlined than the standard track. There's less discovery, which we're going to cover in a later slide. The focus in the smaller claims proceeding is focused on conferences between the copyright claims officer, again, who are decision makers. In a smaller claims proceeding, only one copyright claims officer makes the decision, while in a standard proceeding, all three copyright claims officers will be engaged in deciding the case. So there are some key differences. I like to tell people, if you're like me and you're a talker, you might want to think about filing a smaller claims proceeding, because then you can have a conference where you get to advocate your side of the case. If you like in writing, if it's helpful for you to write all of your thoughts down and really make your case that way, you might want to think about filing a standard proceeding case where more of your case is decided based on what you file. What written testimony you file. Okay, so let's talk about the types of damages that you can get in a CCB proceeding. So the monetary awards cannot exceed $30,000. That's why we're a smaller claims court. The maximum is reduced again to $5,000 for that smaller claims proceeding. For infringement claims, the claimant, if you bring a claim, you may be awarded actual damages, or statutory damages. Now, statutory damages are damages set by the law. Actual damages are a calculation where they take the infringer's profits attributable to the infringement. So if you were a photographer who lost a licensing fee, your damages would be that licensing fee. The CCB does not take, unlike federal court, does not take willfulness into account or award punitive damages. No monetary awards are grounded above the limits. And this is important. The CCB cannot award monetary damages based on physical or mental harm, lost wages, or harm to a brand. Lastly, the CCB cannot order a party to stop or modify infringement or misrepresentation activities. You know, a lot of people just want the infringement to stop. While you can request it as a part of your claim, it's not something that the board can grant. If you really need someone to immediately cease using your work, you might want to file in federal court instead of the CCB. So let's talk about what happens after you file a claim. So after you file a claim with the CCB, it goes through a process called compliance review. Now, compliance review is where the CCB makes sure that your claim meets all of the statutory and regulatory guidelines that are set by the law and the CCB. It's basically that your claim has we basically want to make sure that your claim is a copyright claim and that you are you have included enough information for your defendant to know what your claim is about. So if your claim is compliant, then you proceed to the next step, which is service, where you formally notify your defendant, your respondent, that you filed a claim against them. And then they have, again, the CCB is voluntary. So then we go to the opt-out period where they have the opportunity, they have 60 days to decide whether or not they want to continue in the proceeding. If your claim is not compliant, we give you another chance to fill in some gaps of information. If you need to include more information about what your work was or about how you think the respondent used your work, we'll let you know in a document in an order that'll be posted online that says, hey, we need some additional information. We let you know what we need additional information about. You're given 30 days to fix your claim. And then if your claim is still not compliant, we'll write another order and say, hey, we still need a little bit more information, or maybe your claim is not right for the CCB. And then if your claim is still not compliant after that third try, we'll dismiss your claim, but you do have the opportunity to refile it. However, at any point in that process, if your claim is, if you add that information in and your claim is compliant, you proceed to the next step. Okay, so let's talk about the CCB from the perspective of a respondent, or a perspective from the defendant. So if the CCB finds that a claim is compliant and the claimant serves the defendant with the claim, you have 60 days to decide whether or not you want to opt out in the proceeding. You can opt out at any time during these 60 days and do not have to provide a reason for your decision. If your defendant opts out, the CCB will dismiss the claim, but the claimant can still bring that same claim in federal court. Now, a lot of times we get asked, why would a defendant choose to stay in? Well, one thing is that they know that there is that damages cap, so that they know that they're even the most that they could be on the hook for is $30,000. The CCB is more cost efficient and faster than federal court. So if they want to just get this dispute settled or litigated quickly, then they might choose to stay in the CCB. If they want to represent themselves, they could choose to stay in the CCB and litigate this dispute. Do we have any questions, Jordan? Do you have any questions?
Yeah. So as a respondent, what if I don't want to like participate in the proceeding at all after I'm served?
So that's a great question. So in the documents that you are served, you're provided an opt-out code. So that opt-out code allows you access to a form where you can notify the board that you're going to opt out and that you're going to you don't want to be involved in the proceeding. So in our example, if you see that your work, if you receive a claim, if you receive notice of a claim, it's going to have an opt-out code in that first page, and you'll go to our website, ccb.gov. You'll click the opt-out, you'll click opt out of a claim. It'll shoot you to our filing system. You'll input some information about who you are. You'll input that unique opt-out code, and the CCB will dismiss the case. Again, you have 60 days after you have received the claim to decide whether or not you want to participate. It's a great question. Okay. So once you're engaged in a CCB proceeding, what does it look like? Well, the first step is to get a response from the defendant. So after a defendant responds to the claim, they can include it's basically their chance to say their side of the story. The next stage is discovery. So discovery is the stage of a legal proceeding where the participants exchange information and documents about their claims, defenses, and any counterclaims that they may have. Discovery in the CCB is limited. We have standard questions and standard document requests that each party have to give each other. You can request more discovery if you wish, but there are no depositions, there's no subpoenas, and there is no expert testimony. Before you get into the discovery part of the proceeding, the CCB will hold a conference. It's your first chance to meet the CCB and the CCB officer that is going to preside over your claim. They'll explain everything to you. All of our conferences are virtual, so you'll hop on a Zoom and you'll be able to meet with the Copyright Claims Board officer. Then you'll engage in discovery. Then you'll have another conference where you'll again meet with that officer, talk about if you had any issues with discovery, if you need any more documentation from the other side. And then you'll proceed to the next step, which is the making your case step. So let's take a look at the example of discovery. So Jordan is an author who wrote a novel about her adventures selling vintage records entitled My Life in Vinyl. Jordan is on a music novel forum when she discovers that MB Publishing, a company she has never heard of, is marketing and selling her book. Jordan decides to file her copyright infringement claim with the CCB. I'm bringing back our copyright infringement example because we see a lot of copyright infringement cases. So Maya and Jordan exchange information and documents relevant to the issues in the case. Jordan and Maya answered standard questions known as interrogatories and sent each other documents, including the licensing agreement mentioned in MB Publishing's response, and Jordan's correspondence with the Copyright Office about registering her book. Again, these are questions that are asked in those standard discovery forms. Again, I mentioned, so then the parties engage in conferences and hearings. So a conference is a conversation where the parties or their legal representatives have a chance to discuss the claim with the copyright claims officers. Conferences may be held by one or more copyright claims board officers and will always be held virtually by video conference or telephone conference to allow all parties to participate. Hearings are possible, but not held in every CCB proceeding. If the CCB conducts a hearing, it will also be done by video conference. So after the parties have exchanged discovery, each participant will present their claims or their defense to the CCB through written submissions and supporting evidence. Any participant with a claim or counterclaim could submit sworn statements on their own behalf, sworn statements from other witnesses, any documents that they want the CCB to consider, or and a statement setting forth their position on why they should win the case. So these filings can depend on whether or not you are in a standard proceeding or a smaller claims proceeding. In a standard track proceeding, each party will present their claims or defenses to the CCB through these written statements. In a smaller claims proceeding, the board will schedule another conference with the parties to discuss the issues. And they can orally give a presentation about whether or not on why they believe that they should win the case. Okay, let's talk about our example. So Maya and Jordan each draft their written testimony using the information they gathered during discovery. Both Maya and Jordan include documents that they exchanged in discovery as exhibits. So the reason that you really want to engage in this limited discovery is to make sure that you have all the information that you need to prove your case. So after you get discovery documents in discovery, then you can use them to prove your case in the next section of the proceeding. Okay, Jordan, I want to check in. We did a lot of talking about CCB proceedings and the steps in a proceeding. Do we have any questions in the chat?
There's no questions in the chat. You got a comment from Professor Matima. He said he's going to reach out to you soon, though, and he
Okay,
loves the
great.
panel. And then I guess for me, it'd be like, what if I disagree with the overall determination of the CCB? Can I appeal that at all? And then also, actually, you answered that. I have another question. I'll wait.
Yeah. Okay, so let's talk about the determination. So after Jordan and I have submitted our information about our after Jordan and I have submitted our written testimonies and our documents to the board, the 3 copyright claims officers make a determination. So the final determination includes explanations of the facts and the laws that the CCB relied on to reach their determination. If the parties agreed to settle or dismiss some of or all of the claims or counterclaims, the CCB will include those terms in a final determination if the parties ask for it. So a final determination can also be enforced in federal court. So the determination is basically, you can think of it as a court opinion that says who won and who lost, and if there are any damages awarded. And again, the board will explain all their reasoning. They'll explain the facts that they used, that the parties gave. They will explain the laws, and they will issue a determination. Now, that determination is enforceable in federal court. You asked about appeals. If you don't like that determination, there's a couple of avenues for you to appeal. They're generally a little bit narrower than federal court, but there's kind of 3 steps you can do. So the first is to ask for the board itself for a request for reconsideration. After issuing a final determination, you can request, you can say, hey, I think the Copyright Claims Board made a mistake of fact or law, and you can request the board to reconsider. The next one is a register review. So that's with the Register of Copyrights in the Copyright Office. You can request that the register, this comes after a request for reconsideration. Say your request for reconsideration was denied, you can request review from the Register of Copyright. And that is an abuse of discretion. So you can say the Copyright Claims Board abused their discretion when deciding my case. The last type of review that is possible is a federal court review. So that's in cases of fraud, misrepresentation, or other misconduct. You can say that, hey, there was some fraud in my Copyright Claims Board case. I need a federal court to review it. Or you can say, hey, the CCB exceeded its authority or failed to render a final determination. You can ask the federal court for recourse there. And if there is a default scenario, you can ask for a default to be set aside. Any other questions about CCB, the steps in a CCB proceeding?
Yeah, because earlier you mentioned you could kind of assert counterclaims. What if the
Yeah.
CCB refuses to hear a counterclaim, even if it is an infringement claim, or like a declaration of non-infringement or misrepresentation?
Yeah, that's a good question. Let's backtrack and look at our timeline quickly. So in a response, a defendant can assert a counterclaim. Now, a counterclaim must be tailored to the facts and circumstances of the case at hand. So if Maya and Jordan are fighting about whether or not someone has infringed Jordan's book, we can't then go and talk about Jordan's record label and Jordan's album or Jordan's photography that's not included in the book. So it has to be a counterclaim that deals with the same facts and circumstances that's at issue at the current claim. So the Copyright Claims Board only hears very narrow types of copyright counterclaims. Again, that's copyright infringement, copyright, a declaration of non-infringement, a claim of misrepresentation, which we discussed, or if in very, very narrow circumstances, if you had a contract dealing with the type of claim that you're defending against. So say that there was a contract, a breach, there was a contract issue with the work in an infringement claim, then the board can handle that. But again, that's very, very narrow. So if a defendant has a counterclaim, they're gonna want to let the board know in that response period. Counterclaims do go through the same compliance review process that an original claim goes through. So the board will take a look at your counterclaim, make sure that the board is the type of claim that the board can handle, make sure that the facts and circumstances are aligned with the proceeding that we're in. And then the board will continue the proceeding. But that's a great question. Any other questions about CCB proceedings?
I guess just the last one. It seems like there's a lot of deadlines, and you mentioned earlier you don't have to be an attorney to kind of represent different things. Are there any safeguards that are kind of like grace given to people who are doing it maybe on their own or maybe not as experienced?
Yeah, that's a great question. So the CCB gives you a schedule, will let you know your deadlines in advance, and we'll give you a schedule. And if any point you're looking at that schedule and say, hey, I think I need more time, you just have to let the board know, let the board know the reasons why you need more time. Say, hey, I'm working, I'm representing myself, I need more time, and let us know, and we can adjust the schedule accordingly. But you get a firm schedule. There's certain things where the law tells us how many days we have, but there's a lot of leeways, especially when you get to this part of the proceeding. So if you look at a proceeding from start to finish, once someone files a claim, they have the law gives them a certain number of days to serve. So that the law gives them 90 days to complete that formal service. In a movie, that's when someone is handing you that service packet and saying you're served. You have 90 days to get that done. Afterwards, the law does give your defendant that 60 days to opt out. And after, no one opts out, the board will start another clock. That next clock is the clock for the claimant to finish paying their filing fee, and for the respondent to sign up for our ECCB claim system. Thought I had a slide on that. After that, the board will issue a scheduling order, and the scheduling order will cover all of the dates that you see here. So we'll give you 45 days to write your response. If you need more time, again, let the board know. It'll schedule a pre-discovery conference. If your pre-discovery conference conflicts with your work schedule, let the board know. It'll give you another 45 days for discovery. If Jordan and I are engaging in litigation and we say, hey, we need some additional time to get this discovery, to exchange these documents, all you got to do is let the board know. And if you need more time to make your case, to write your written testimony, it can be, that schedule is somewhat flexible. That's a great question. Okay. So we talked about final determination. We talked about how you can appeal a CCB determination. Let's talk about where you file a CCB claim. So ECCB is the electronic filing and case management system for the board. Participants can register for ECCB to file, respond, receive, and review any documents related to the proceeding. Anyone can go online and view unrestricted documents through the public case search feature without registering. In order to register for ECCB, you're going to need a login.gov account. If you have ever applied to a federal job, or if you've completed the TSA pre-check form, you already have a login.gov account. The next great question is, what if you need help? So there are various resources on ccb.gov. The first is the handbook. So the handbook is a step-by-step guide to help you file, respond, complete discovery, write your written testimony, or engage in any other part in a CCB proceeding. They're broken up, the handbook is broken up into chapters, so you only have to review the step that you're on. So if you're filing your claim, if you want to file a copyright infringement claim, I would encourage you to look at the handbook and look at the starting an infringement claim section of the handbook. It's going to walk you through a step-by-step process of what you need and things to think about as you're filing your claim. The second thing I want to talk about is our pro bono assistance page. So some lawyers lawyers, law school clinics, or organizations may be available to provide legal assistance or representation on a pro bono basis, which means you won't be charged for their services. The CCB maintains a list of these organizations on our website. The last thing is that you can reach out to the board at asktheboard@ccb.gov and ask any procedural questions you might have, any general questions about the board. We cannot give legal advice on your particular claim, but we can give you a ton of information about copyright generally, or about next steps, or about how to start a claim. I know that IIPSJ works with a lot of law students. So if you're a law student who wants to get involved, qualified law students are also able to represent parties in a CCB proceeding. To be qualified to represent someone in a CCB proceeding, a law student needs to work with a law school clinic or a pro bono services organization that has a connection to their law school, comply with whatever state that they're physically located in when working on their proceeding, have completed their first year of law school, and have completed any relevant training required by their own clinic or supervisor, and work under the supervision of a lawyer who's qualified to practice. But we have had students represent people in front of the board. We love when law students represent people in front of the board, and they do a great job. Where can you get more information? You can get more information on ccb.gov, or you can subscribe to our Newsnet service. That's how you get any press releases or up-to-date information about the CCB. So let's spend some time answering some more questions. I don't think we have any in the chat, but Jordan, why don't you, I know that you had some extra questions stored for us.
You mentioned earlier, some people can come to the CCB when they have a pending application. So do you need to have this work registered before you bring a claim?
That's a great question. So when you're filing a copyright infringement claim, you need a copyright registration, or you need a pending application for registration. So what you want to do is you want to go to copyright.gov and file go to their ecosystem and start your application. You need a completed application. So that means you submitted a deposit to the office, that you've completed the application, that you've paid your filing fee. Once you do all three of those things and submit it to the Copyright Office, you're given a 12 to 13 digit number that you can then use in your Copyright Claims Board claim. And so that means you can file that claim while your application for copyright registration is still pending. And kind of get a head start on your claim.
And kind of for the law student who wanted to represent in the CCB court, is more information on the website, or is there a specific way?
Yeah, there is more information available on our website. So you want to go to copyright.gov and go to our directories page and go to the pro bono assistance page. There's more information there. We also have a handbook chapter on representation. It's going to give all of the stuff that law students need to know about representing people or entities or businesses in front of the CCB. It also gives people who are looking for this type of representation more information.
And then there's a question in the chat. What kind of doctrinal training do law students need to prepare to appear before the CCB?
Yeah. So our regulations state that law students need to complete their first year and then comply with if they're working for a clinic or working through any training required by their supervisor that they're working under. There is no formal doctrinal requirement, but I'd say our most successful students have at least taken a base level IP class, so a base level intellectual property class before participating before the board. And that way they have a working knowledge of copyright. Great question.
And then kind of with the court, is it similar to, I guess, civil cases where you can possibly recover attorney's fees and costs, or is it different there?
Yeah, so the board only awards attorney's fees when we find bad faith. Now, bad faith means that someone filed the claim for an improper person and an improper purpose and has kind of a technical meaning under the law. So generally speaking, the board does not award costs and attorney's fees in that damages number. It's one reason why a respondent or a defendant may think to not opt out of a CCB proceeding because they know they're not going to be on the hook for the other party's attorney's fees. On the other hand, it's something to consider if you think that it's something to consider if you think that you're going to need an attorney to help you file your CCB case, whether that attorney's fees won't be covered. However, compared to federal court, the CCB is a faster, more streamlined process. So hopefully that attorney is working less hours on your case than if you were to pursue it in federal court.
And once they award damages or make a determination, what happens if a party that is supposed to pay the damages does not comply with the CCB order?
Yeah, so the damages, CCB determinations and damages are enforceable in federal court. The great thing about coming to, I will say the best case scenario is that's the person, if you win your CCB claim for, let's just say $2,000, that your respondent pays you and you got everybody goes their separate ways. But if you have a respondent who is unwilling to pay after the CCB has awarded you damages, what you do is you file a case in federal court, but it's a different kind of case. It's a default damages recovery case. And you basically tell the federal court, hey, this person isn't paying. Federal court gets involved and you can recover your damages that way through garnishment and other enforceable recourses that federal court has that we don't have here at the CCB.
And I think there's a question in the chat.
Mhm.
Has it been especially challenging to work with pro se litigants before the CCB?
No, actually, I think that our pro se litigants do a great job of advocating for yourself. I have a slide that talks about some statistics here. So 65% of our participants are self-represented. And I think it's, for me, I'll speak personally, it's inspiring to see people advocate for themselves, whether that be defending themselves in a case. We've had pro se respondents who have defended themselves in a CCB proceeding and come out victorious. We've had claimants who have filed claims and advocated for themselves and got monetary damages awarded. I think that the CCB was built for people to really advocate for themselves and not necessarily need an attorney, but be given a forum to let a decision maker hear their side, hear their copyright dispute. And we're always willing to work with pro se parties in terms of explaining procedure, explaining copyright law. Like I said, we can't give legal advice, but if you can succinctly and thoroughly tell your side of the dispute, we'll take care of figuring out the copyright law that applies.
And then there was, I think it's a comment. So you have to enforce your judgment, debtor/creditor law.
Yeah. So and that isn't a scenario where someone is choosing not to pay, or if you go with your default judgment and you're unable to find to recover your damage from your determination damages from a respondent. There have been a few, I think one, maybe two cases in our few years of operations where we've seen a CCB participant who was awarded damages go to federal court to enforce their judgment, but it's not something that happens very regularly. I'll say at least in our first few years here.
And then how does the office currently make the public aware of the CCB, especially given that one does not need to hire an attorney?
Yeah, so we're working on it. We're currently speaking on panels like this. We have webinars on our website. There are a number of ways that we try and reach out to the public and let them know that the CCB exists. Another way that we're trying to do that is by reaching out to our stakeholders. And you know, let organizations and entities who artists and creators and users of copyright trust know about the CCB. IIPSJ is obviously one of those that lets us come and talk about the CCB and the ways that it can be used by the people that that know and work with IIPSJ. Oh, Jordan, I think you're on mute.
Sorry. It
No
was just a
problem.
comment just saying that this was excellent and you put together an excellent webinar.
Great. Is there any other questions? I know we have about 10 more minutes. Okay,
I don't see any more.
Okay, not seeing any. I'm gonna kick it back to Victoria, who's gonna close us out.
Hi, great. Thank you, Maya. Thank you so much. That was so informative. I really want to thank you as volunteering to serve as a guest presenter for the IP for the People webinar series provided by the Institute for Intellectual Property and Social Justice. I know I definitely learned something new today, and I really hope that everyone in the audience did too. This was all recorded, and we'll be sharing this on our YouTube page at a later date, and we'll be sending an email out to everyone once that's uploaded. We hope that you'll subscribe to our newsletter so that you can be informed of future events, including the next session in this webinar series, which will take place in June. This session will focus on fashion law and will be hosted by Marisa Terrell, who's an attorney advisor at the USPTO Trademarks Customer Outreach Office. So thank you to our wonderful speaker and our moderator today and to everyone who participated tonight. I hope you all have a wonderful evening. Thank you.